So we might get started. Welcome everyone to today's Family and Domestic Violence and Employment Law webinar. We're so excited to have you join us. As we start, I'd like to acknowledge the Wurundjeri people who are the traditional custodians of the land that we're presenting from today. I'd also like to pay respect to the elders past, present and emerging of the Kulin Nation and extend that respect to other First Nations community members present. My name's Amanda. I'm the Communications Manager here at JobWatch. Today, I'm here to run the session behind the scenes, doing all the tech stuff, supporting our principal lawyer, Gab Marchetti, who will be presenting today's session. So a little bit of housekeeping first. Thank you to everyone who has submitted questions when they registered. We've read all the questions and we've incorporated them into today's presentation. Don't forget, if you have any other questions during the presentation, just drop them into the Q&A function at any time. We have some time set aside at the end to answer questions. Given the topic of today's webinar, we'll also be talking about sensitive topics that may be upsetting for people. So if these topics trigger a response from you and you need to log off briefly, we completely understand. Please take whatever time you need. Whenever you feel able to talk about it, we encourage you to call JobWatch to discuss your employment law concerns and we'll see what we can do to help. You can always also contact other avenues of emotional and mental health support, so your GP, Lifeline on 131114 or Beyond Blue on 1300 224 636. I'll drop these numbers into the announcements tab so that you've got them on hand as well. If your employer offers an EAP program, you can always contact them as well. So in terms of technology, this is a Microsoft Teams live event. So even though you can see and hear us, we can't see and hear you. You can still interact through that Q&A function though, and I'll be in the background when Gab is presenting, so I'll try and help manage any technical questions that you have. We also have closed captioning available in this webinar. You can see it on the bottom of the screen there. It is auto-generated, so there may be a few misspellings along the way. If at any point anything doesn't make sense, please make a note of it in the Q&A function and we'll clarify it as soon as possible. There is also an option to have this auto-closed captioning auto-translated into 6 different languages, being Arabic, Chinese, Hindi, Portuguese, Spanish, and Urdu. And, you know, being a legal service, we also have to add a disclaimer before we get started. So what we're discussing here today is general legal information. It's not legal advice. We always recommend that you or your clients should obtain legal advice from a lawyer about their particular situation before acting on any of the information that's being provided here today. One final note as well, this webinar is being recorded. So once the recording is uploaded to our website, we encourage you to share the information with your colleagues as well. I think that's it for me. So I might hand over to our principal lawyer, Gabrielle Marchetti, for today's presentation. Over to you, Gab.
Thanks very much, Amanda. Okay, welcome everyone. Thank you for making the time to be here. It is a very important topic, talking about family and domestic violence and employment laws. Now, these are the things that I want to cover during the next hour that we have together. I'll start off by talking about JobWatch and explaining what we do and how we can help you, or we can help your clients, the people that you're in touch with. We have a very broad attendance group today, so you are from all over Australia and all sectors. I'll try and make this as relevant as possible to everyone who's in attendance. We'll start off after I explain what JobWatch does. We'll start off by really looking at some stats and the terminology that's used and understanding why it's so important that everybody has a clear understanding of their rights when it comes to family and domestic violence and employment law. And then we'll get right into what the entitlements are. So we'll start off by looking at leave and flexible working arrangements. Then I'll talk about unfair dismissal and then general protections disputes. I'll touch on unlawful discrimination and occupational health and safety. Thanks, Amanda. So starting off with JobWatch, who we are and how we can help you. JobWatch, as most of you will know, is a community legal centre. We are one of about 200 CLCs, community legal centres, across Australia, and lots of you will know that community legal centres are independent of government. That is very important. We are not a statutory agency. We are not like a legal aid office or the Fair Work Ombudsman or the Fair Work Commission. We are all independent of government. We are not-for-profit organisations. We do get funding from government, and in the case of JobWatch, we have funding from both federal and Victorian state governments. We are funded to provide 4 main services. So the one that we are best known for is the one that appears in the second picture here, which is the telephone information service. And that telephone information service operates across Victoria, Tasmania and Queensland. So if you or your clients are in one of those states, then of course that's the best way to get people to contact us, through our telephone information service, and the phone numbers for that telephone information service will be at the end of this presentation. Through that telephone information service, which operates Monday to Friday from 9 till 5, and on Wednesdays we are open until late, until 8:30. So 9 till 8:30 on a Wednesday, otherwise Monday to Friday. And we give very, very tailored information. So you can call us about any query that's related to your paid work. You don't have to be an employee in the strict sense of the word. If you are in paid employment, and regardless of what stage of your job you're at, whether you're right at the start or right at the end, you can give us a call and we will give you free and confidential tailored information about all the rights that you have in your specific situation. Now, apart from that telephone information service, we do have a small legal practice that takes on cases through the various courts and tribunals, but this is only for Victorian clients. And at the moment, we have a specific project that is being funded by the Victorian government to help women in particular, but of course anyone who is affected by family and domestic violence and has work issues. So the legal practice will prioritise those kinds of matters if they come through. You can get in touch with us directly if you want, or as I said before, you can call through our telephone information service and then one of the lawyers will pick up that issue. We also conduct community legal education, so hence this webinar today. That's a very important part of what all community legal centres do. And finally, but also very importantly, we engage in law reform, and we always try to improve the laws for all workers. Thanks, Amanda. Now, some points about the terminology that we use. So we all know that family and domestic violence, and by the way, when I use FDV, everyone should know I'm referring to family and domestic violence. It is a gendered issue. The majority of people who experience family and domestic violence are women, and we'll have a look at some stats in the next slide or in a couple of slides' time. So we do tend to use gendered language, but I did want to make the point that there is research around about how what terrible stats there are when it comes to LGBTIQA+ communities experiencing family and domestic violence. And so we just need to be mindful that the language doesn't make people in these communities invisible. Thank you, Amanda. This next slide really just shows some of the recent headlines that have appeared in the media. We all know there is growing media attention and of course therefore government attention that is being given to this issue of family and domestic violence. You can see just these are headlines from the last 12 months or so. In particular, the COVID pandemic and the lockdowns that we've had have meant that women have suffered in even greater numbers. And Amanda, if we can go to the next slide, I want to have a look at some of these stats. So shockingly, 1 in 4 Australian women have experienced since the age of 15 physical or sexual violence by a current or previous partner. Almost 10 women are hospitalised every day because of being assaulted by a current or former partner. On average, 1 woman a week is killed because of violence from a current or previous partner. I mean, these are horrendous stats, obviously, between 55 and 70% of women who are experiencing or have experienced family and domestic violence are in the workforce. So that's about 800,000 women, or 1 in 6 female workers. So it is absolutely a workplace issue. All workplaces, and whether we are employees or employers, we all need to understand what our rights and responsibilities are when it comes to family and domestic violence and work. Thank you, Amanda. All right, so let's get into what the employment entitlements are. And I'm going to start with the Fair Work Act. And of course, many of you will know that the Fair Work Act is like the little Bible of all employment lawyers. We have it on hand and we go through it regularly. It is the main piece of legislation, but certainly not the only piece of legislation that's important. But I do want to make the point for anyone who is listening to this presentation from outside of Victoria. In Victoria, the vast majority of employees are covered by the Fair Work Act, because the Fair Work Act applies to national system employees, and the same goes for Tassie and Queensland. However, if you're listening to this presentation from a state or a territory where you have a lot of employees that are not national system employees, then please keep that in mind. So the Fair Work Act has, it's like a book basically that we all often read. Chapter books and pieces of legislation are exactly the same. They're all broken up into chapters. And there is a part of the Fair Work Act that sets out the national employment standards, and lots of you will have heard about the national employment standards already. These national employment standards, which are often shortened, the acronym is the NES. So the NES is basically a set of 10 minimum employment standards that apply to these to all national system employees. And these 10 minimum standards include things like leave, so that's all forms of leave, not just the leave that I'm going to be talking about today, which is specific to family and domestic violence, but also things like annual leave and other forms of leave. It also covers notice of termination, redundancy pay, etc. So all those types of entitlements are within the NES. Now, the ones that I want to focus on, because they're relevant to family and domestic violence, are firstly this entitlement to take unpaid family and domestic violence leave. And that appears, especially the lawyers who are listening will be interested to know the specifics of all the sections. So this is section 106B, and it was introduced, it came into force not that long ago, just at the end of 2018. So family and domestic violence is defined in the Fair Work Act. The Fair Work Act tells us that it is violent, threatening or other abusive behaviour by a close relative of an employee that seeks to coerce or control the employee and causes the employee harm or to be fearful. Important to note that this section has not been tested by a court yet. So the question of what kinds of behaviour are going to amount to family and domestic violence for the purpose of this provision, that's all still untested. A court is yet to interpret this provision. We don't know, for example, whether let's say a spouse who is or a former spouse who's repeatedly breaking child or pet custody arrangements, or returning belongings to the wrong location, or leaving valuables in public places, that kind of behaviour, will that amount to family and domestic violence? We don't know yet. I also want to clarify that close relative, which is underlined there in blue, that is defined. It's defined in section 106B subsection 3, and it basically is defined as a member of the employee's immediate family, and immediate family, by the way, has a very broad definition, or it also includes people who are related to the employee according to Aboriginal or Torres Strait Islander kinship rules. Thanks, Amanda. So, who's eligible for this unpaid family domestic violence leave? Well, the good news is all employees, including casual employees, are entitled to this leave, and the leave is specifically 5 days of unpaid leave within a 12-month period. Another bit of good news is that the entitlement, it doesn't accrue over time, so you don't have to wait. Right from day one when you start your employment, that entitlement exists in full. So if you are in an unfortunate position where you need to access 5 days of unpaid leave very soon after you've started your employment, you can access that. You don't have to feel like you've got to wait a minimum period before you've got that entitlement. The other thing I want to say here is that it is an unpaid entitlement, so please keep that in mind, but it's always really important. I'm only telling you what the minimum standards are, what your minimum entitlements are within the Fair Work Act. You may be covered by an enterprise agreement, which gives you more generous entitlements. So your enterprise agreement, which would be, you know, a booklet that sets out all your minimum terms and conditions in your specific workplace, you need to check that because it may well have some kind of entitlement to paid family and domestic violence leave. But at the moment, the way the law stands, the minimum is to the unpaid leave. I have also put everyone in brackets to please note that the Fair Work Commission is currently reviewing entitlements in a whole lot of modern awards. And interestingly, just in April, the ACTU wrote to the Fair Work Commission asking for this review to commence urgently because of the increased incidence of family and domestic violence during COVID-19. And so the Fair Work Commission is in fact prioritising this. And one of the questions that they're going to be focused on during this review is in fact whether there should be a paid entitlement to family and domestic violence leave in modern awards. So keep an eye on that. All right, so what are the requirements? If you do want to access the unpaid family domestic violence leave, well, you have to, of course, show that you are in fact experiencing family and domestic violence and that you need the leave in order to deal with an aspect of that family and domestic violence. So, for example, you need to attend court hearings or you need to relocate, etc. And you also need to show that it's impracticable for you to do those things outside of your ordinary hours of work, so that there's some justification given to your employer about why you actually need to have that leave. You do need to give notice to your employer as soon as practicable. That's always that, you know, the magic term, as soon as practicable. That, depending on the circumstances, may even be after you've taken the leave, because of course if in that particular moment the situation is very dire for you, then you may not have a chance to contact your employer until you've actually started your leave. But it will always depend on the circumstances. If you can, ideally, you should always contact the employer before you start your leave, and you tell them exactly how long you think you will need and why you need that. You also should give your employer any evidence that you think a reasonable person would require in order to understand why you need that leave. So, for example, you might want to give your employer copies of court documents that you've filed. Your employer does have confidentiality obligations, so they must keep any evidence that you've given to them and notification about wanting to take this kind of leave. They must keep it all confidential. Thanks, Amanda. All right, so that's the unpaid family and domestic violence leave. The next type of leave that I want to focus on is also in the NES, so the National Employment Standards, which is in the Fair Work Act, everyone. And now we're going to talk about personal or carers leave. And for anyone who wants to know the specific sections, we've got the entitlement to paid personal or carers leave in section 96 of the Fair Work Act. and then the entitlement to unpaid carers leave is in section 102. So here you can see in the first bullet point that all permanent employees, so I'm not talking about casuals now, are entitled to a total of 10 days of paid leave. So of course, casuals, we're going to get to casuals in a sec, they are entitled to unpaid leave, but if you are a permanent employee, then you're entitled to a total of 10 days of paid leave per year. And this time, this kind of leave does accrue over the course of the year. So you won't start your first day of work and automatically have your 10 days up front. You need to work over the course of the year and you'll accrue your 10 days. So there are also notice and evidence requirements for this kind of leave, and you will be eligible to take personal or carers leave if you are experiencing family and domestic violence leave and you can't go to work, you're not fit to go to work because you are ill or injured. So you're sick or you are injured because of the family and domestic violence. Or the carers leave aspect is that you're needing to take time off because a member of your immediate family or your household is experiencing family and domestic violence leave, and that person needs you to care or support for them because they are injured or they are ill or they've had an unexpected emergency, and that's why they need you to care or support them. You've got in the smaller font at the bottom that casual workers can access 2 days of unpaid carers leave for this reason, you know, for if they are sick or injured themselves or if they need to care for or support a member of their immediate family or household. But remember that the key difference between this kind of paid leave and the unpaid family and domestic violence leave is that when it comes to the personal or carers leave, you really need to show that it's not about attending appointments or relocating or doing other things that are associated with the family and domestic violence leave. If you're wanting to take paid personal or carers leave, you need to be sick or injured. Thanks, Amanda. So let's have a look at a practical example to understand all of this. So Jean tells you that she's currently working, but she's worried that she's going to lose her part-time job. She has been experiencing family violence, and because of this, she sometimes doesn't attend her set shifts. Her employer has recently given her a formal warning due to these absences. So if you're in this situation and you're supporting Jean and Jean's telling you that she's really worried that she's going to lose her job because she's been missing some shifts, then of course you're going to be worried and wanting to look after her so that she retains her job. That's really the ultimate aim here. We want to prevent people from being dismissed in these situations, and we want to make sure that Jean knows that she has leave, certain types of leave that she can tap into. Now, she might want to ask for up to 5 days of unpaid family and domestic violence leave, or she might need to tap into the paid carers, or no, not carers leave, I beg your pardon, because she's actually the person directly affected. She might need to tap into the paid personal leave. We don't actually know whether the time that she's needing to take off is because she's in fact sick or injured on those occasions. If she is, then of course we need to make sure that she understands her entitlements to paid personal leave. But I would always encourage Jean, if Jean is talking to you about this kind of issue, please encourage her to call JobWatch's telephone information service, or if you are a lawyer or a caseworker helping people in these situations and you want to make a direct referral to one of the JobWatch lawyers, then please contact us through our admin number and ask to speak to one of the lawyers directly, and we can take on those warm referrals directly from lawyers and caseworkers. We would of course want to check whether Jean is covered by a modern award or an enterprise agreement. If she's covered by an enterprise agreement, then we would look up that enterprise agreement to see whether she might have some more generous entitlements when it comes to family and domestic violence leave. Okay, thanks, Amanda. The next entitlement that we want to look at is the entitlement again in the NES, so the National Employment Standards of the Fair Work Act, and this is an entitlement to ask for flexible working arrangements, and it's section 65, everyone. So under this section of the Fair Work Act, employees can request flexible working arrangements if the employee is experiencing violence from a member of their family, or if they need to provide care or support to a member of their immediate family or household, and that person requires the care or support because they're experiencing violence from a member of their family. Now, what are some examples of the kinds of flexible working arrangements that you might ask for? Well, changes in your hours, or changes in your start and finish hours, or changes in the location of work. So you might be asking to work from home, or quite the opposite. You might ask to work from the office where, you know, whilst most of the other employees perhaps are working from home. Whatever the change of location might be, if the employee feels safer working in a different location, that could absolutely fall within the kind of request that you make for flexible working arrangements. Thanks, Amanda. So there are some requirements if you want to make this kind of request as well. So for a start, if you are a full-time or part-time permanent employee, you need to show that immediately before you've made this request for flexible working arrangements, you've worked for your employer for at least 12 months. Same with casual employees, but in the case of casual employees, you need to actually show that you have been working on a regular and systematic basis for at least 12 months. So your hours, if you've been a casual, can't be completely random and unpredictable. They need to have been regular and systematic for the last 12 months. And if that's the case, then you still are eligible to make this request for flexible working arrangements. You do need to make your request for flexible working arrangements in writing. And once you've given that to your employer, the employer has to respond in writing within 21 days, telling you whether they accept or they refuse. And can we go to the next slide, please? So they, under the Fair Work Act, the employer can only refuse this kind of request on reasonable business grounds. So if you, the employee, you've made a request for flexible working arrangements, you get the response from your employer and you don't believe that they have reasonable business grounds, or if they simply haven't responded to you within the 21 days, then the best thing to do is, of course, if you are a union member, contact your union and let them know. But if you're not a union member, then you should contact the Fair Work Ombudsman. And the Fair Work Ombudsman, everyone, their phone number, they have a telephone information line. The phone number is 13 13 96, so 13 13 96, or you can jump online and their website is fairwork.gov.au, and they have a chat function where you can make requests for assistance via their chat as well. Now, we're going to be talking about some of these complaint types in a sec, but just to quickly flag that depending on whether the employer's refusal to grant you the flexible working arrangements results in a dismissal, in a termination of employment, if it does, you might want to consider going for an unfair dismissal or a general protections involving a dismissal claim. And you have to do, if you're going to go ahead with one of those claims, you have to make the claim, you've got to lodge it within 21 days. So that's something that's really important. I'm going to keep emphasising that. Alternatively, if the result of the employer not granting you the flexible working arrangements results in you feeling like you've been treated badly, but it hasn't actually resulted in a termination of employment, then you might want to consider making a complaint that would be, for example, a general protections non-termination claim, and you've got 6 years for that kind of complaint. Okay, thanks, Amanda. So let's have a look at another practical case study. This is how we assisted one of our clients, and of course she's been de-identified. We've given her the name Suniti for the purposes of this case study. So Suniti was employed on a full-time basis. 6 months into her employment, Suniti started experiencing domestic violence. Her abusive partner began contacting Suniti's workplace and threatening her. As a result, Suniti missed 2 days of work while she arranged an intervention order. Suniti's employer expressed dissatisfaction with her inability to separate her personal issues from work. Suniti didn't attend work the next day in order to seek medication or medical attention for her distress, and her employer issued her with a written warning in relation to the absences. Suniti was forced to flee her home later that month and was unprepared to come into work the next day. Her employer then requested a face-to-face meeting. Suniti responded to the request by asking about her entitlement to domestic violence leave and also flexible working arrangements. Her employer denied that she had any entitlements and she was dismissed the next day. So Suniti came to us and we helped her with a general protections involving termination claim. So that's the kind of claim that has to be made within 21 days, everyone, 21 days of the dismissal. We argued that Suniti was dismissed because she had exercised her workplace right to take unpaid family and domestic violence leave and that she had requested the flexible working arrangements. And the matter settled out of court. It was a favourable settlement for our client. So that, you know, that ended okay. Of course, it's not ideal because Suniti would have much preferred to stay in employment. But of course, when the employment does go pear-shaped like this, then it's important to act quickly, get a complaint lodged and try and resolve it so that at least you cover your financial losses, the time out of work. Thanks, Amanda. Okay, now let's focus on unfair dismissal. And many of you, of course, are probably already familiar with how unfair dismissal works. I just want to make it clear for those of you who may not be familiar with the unfair dismissal jurisdiction. This is a kind of complaint that you can make to the Fair Work Commission if you are arguing that you are an employee, you were an employee, you meet the minimum employment period, which is outlined in the box over there on the right-hand side. So depending on the size of your employer, if you work or were working for an employer that had fewer than 15 employees, then you've got to have been employed there for at least 12 months. But if your employer had 15 or more employees, then the minimum employment period is 6 months. So if you've got that minimum employment period and you are otherwise eligible for making unfair dismissal claims, then you go to the Fair Work Commission and you argue that your termination was harsh or unjust or unreasonable. And in considering whether your termination was in fact harsh or unjust or unreasonable, the Fair Work Commission is always going to really focus on two main questions. The first question is, well, did the employer have a valid reason for dismissing you? Was that valid reason based on your performance or your conduct? Or was there a genuine redundancy? If it was a genuine redundancy, if the Fair Work Commission considers that it was a genuine redundancy, then unfortunately your unfair dismissal claim will automatically fail at that point. But even the second question then for the Fair Work Commission is, even if your employer did in fact have a valid reason that was based on performance or conduct, did they actually follow a fair process in implementing that dismissal? And the point here is that in recent years, family and domestic violence has been considered a relevant factor when the Fair Work Commission has determined whether an employee's dismissal was harsh or unjust or unreasonable. So this can be a very good mechanism to use if you or one of your clients or someone that you're supporting loses their job and it's somehow associated with family and domestic violence. Thanks, Amanda. So let's have a look at this example. This is I've given you the citation, the decision back from 2015, and this was someone who had come to JobWatch, and we represented her in these unfair dismissal proceedings. So the employee in this situation was a full-time architectural draftsperson. She worked for the same employer as her partner did, as her domestic partner. So both she and her partner obviously had the same employer. She was experiencing family and domestic violence, and she went and applied for and got an intervention order against the partner, and that intervention order meant that the partner couldn't come within 3 meters of her. So as you can see in that fourth bullet point, the IVO, which is the intervention order, allowed her to continue to work in the same office, but guess what? The employer had an in-house lawyer who basically bailed up our client in the lunchroom one day and said to her, you know what, I've heard about the intervention order. I don't think it's going to be practical for both of you to keep working here, and I've actually drafted a resignation letter for you. So after lunch, when you're ready, come in to see me in my office and you can sign that resignation letter. Now, thankfully, she came straight to us and we were able to put in the unfair dismissal application within the 21 days. We ran that all the way to a hearing, and the Fair Work Commission found that the employer did not have a valid reason for dismissing her. Well, firstly, the Fair Work Commission had to agree with us that this was in fact a dismissal, that it was not a resignation, and they did find that it was a dismissal. But then importantly, there was no valid reason for the dismissal, and therefore the dismissal was unfair. So that was a very good result. Now these next few examples that I'm going to give you were not our clients, but these are important decisions to be aware of, all unfair dismissal decisions. So this one's back from 2016. I've tried to give them to you in chronological order so that you can see how the law's developing in this area. So in this case, the employee was a solicitor in a law firm, Ms. King, and she was employed by this law firm called Lee and Lyons, and she was dismissed for repeated absences, and all the absences, the evidence was that they were all in connection with the domestic violence that she was experiencing. She actually told both the HR manager and the special counsel who she reported to about the family and domestic violence leave very shortly after she started there. She told them that she'd experienced an episode of family and domestic violence, so they knew that this was in the background. But then she didn't necessarily tell them every time after that that any absences were connected to the family and domestic violence leave. So over time, the employer gave evidence to the Fair Work Commission that they didn't know of her whereabouts, that she would, just turn up late or not turn up on time, and that they didn't know what this lateness was due to. She was eventually dismissed for misconduct because she failed to inform the partners that she wouldn't be back in time at a particular time, and that was on an occasion when her family domestic violence trial was delayed. And she basically on that occasion hadn't told the employer what the reason was. Now the Fair Work Commission held in this unfair dismissal case that despite breaching her obligations to her employer, the dismissal was unfair. So the Fair Work Commission agreed with Ms. King that that she hadn't been given an opportunity to respond. she hadn't been notified of the reason for her dismissal before actually just being told, this is why we are dismissing you. So, you know, there is an obligation on employers to go through a fair process to put any allegations about conduct or performance to an employee before any final decision is made about terminating. And the Fair Work Commission found that those things hadn't happened here, and therefore this was an unfair dismissal. And they awarded Ms. King over $11,000 in compensation. Thanks, Amanda. So this next example, now 2018, another unfair dismissal decision, and in this one, the applicant was an employee of the supermarket chain IGA, and she was dismissed again due to frequent lateness and leaving the store during shifts without notifying management. And she cited family and domestic violence as the reason for her behaviour. Now, in this case, the Fair Work Commission actually found in favour of the employer, so in favour of the IGA, basically. So I really want to emphasise for everyone, and the lawyers who are in attendance will know this, no two fact scenarios will ever lead to the same outcome. Every single case will turn on its own facts. There have been a number of unfair dismissal decisions where family and domestic violence has meant that the employer, you know, on the evidence that was before the Fair Work Commission, the Commission was able to say, yes, employer, you didn't actually behave properly, you made knee-jerk reactions, perhaps you reacted too impulsively, you didn't go through all the proper processes, etc., and therefore this was an unfair dismissal. But then there are other cases like this one that you've got before you here, where the Fair Work Commission basically said the employer had already issued you, employee, with a series of formal warnings, and they had also issued you with a final warning. You knew very well that a termination was likely if you continued to be late, and the employer had been talking to you on a weekly basis about these issues and about your behaviour. You were on notice of the fact that that kind of behaviour was not able to be tolerated any longer. So the Fair Work Commission basically was convinced by the employer's evidence that they had gone to extraordinary lengths to assist her. They'd been tolerant and supportive of her personal issues over a long period of time. So in this particular case, it was held that there was no unfair dismissal and that the employer had acted. They both had a valid reason and had followed a fair process in implementing the termination. Thanks, Amanda. Another decision, so now from last year, from 2020, and in this decision, you can see that the applicant had been working as an industrial administrator for the TWU for over 14 years when her position was suddenly made redundant with no notice or consultation. During the last 3 months of her employment, she needed to attend hearings relating to family and domestic violence, and she had kept her employer informed about this. And the Fair Work Commission held in this case that the family and domestic violence did contribute to the employer's decision to make her position redundant, and therefore this was an unfair dismissal. And they focused really on the harshness and on the unreasonability elements of this dismissal. Thanks, Amanda. So now let's have another look at another client who we've assisted. So Sally. Sally worked for a business that was owned and run by her husband's family. One day, Sally's ex-husband refused to return the children after their weekend visit. Sally went to the police, who suggested that she contact her ex-husband's parents to ask them to persuade him to return the children. I beg your pardon. So that all seems like a bit of a convoluted way, but that's basically what the police told her to do. Sally contacted her in-laws, but that conversation went very badly, and they ended up having an argument. So soon after that, Sally made a post on her private social media account referring to her argument with her ex-in-laws. She deleted the post a few days later, but her employer found out and summarily dismissed her. So summarily dismissed her means, you know, they did that without any notice, just with immediate effect. And Sally came to JobWatch, and on her behalf, we lodged an unfair dismissal application. We argued that there was no valid reason for the dismissal because, of course, the posts were not related to her duties, and they were made on a personal account and outside of work hours. And we also argued that she had not been given sufficient warning or any opportunity to respond. And again, as is often the case, these matters more often than not resolve before a hearing. So there is no publicly available decision about this case, but I wanted to share it with you as another example of how you can use unfair dismissal, the unfair dismissal complaints mechanism. Thanks, Amanda. All right, now moving on to the general protections mechanism, and the general protections disputes are a different type of complaint that you can make. It's an alternative to unfair dismissal. So unfortunately, you cannot ever lodge both claims just to protect yourself, just in case. You can't go for both an unfair dismissal and a GPD, as it's called, general protections dispute, at the same time. You must elect which one you want to go for. The general protections is quite different to unfair dismissal, a completely separate type of complaint. In terms of the eligibility that you can see in the box, you don't even need to be a current employee in order to be eligible. These laws protect and extend to prospective employees and independent contractors as well, and there is no minimum employment period. So basically from day one that you start your employment, if you feel that you have been subjected to adverse action and the reason that you've been treated badly, subjected to that adverse action, is because, so there needs to be that causal connection, because you have a workplace right or you try to exercise a workplace right, then you can go for it and lodge a GPD claim. Now, the adverse action could be dismissal, and if it is dismissal that you're talking about, then quickly get your complaint in quickly. You've only got 21 days to get that complaint lodged. If the adverse action is something less than dismissal, so for example a demotion, or you've had your hours altered, then that is still adverse action, but you've actually got 6 years to make your complaint, not 21 days. So 21 days is if it's a dismissal. Thanks, Amanda. So another type, so the first, that last slide was when you are complaining that your adverse action was because of a workplace right. So that's one type of GPD claim. Another type of GPD claim is if you complain that you have been dismissed because of a temporary absence from work due to illness or injury. So it is a temporary absence if you haven't been on leave for more than 3 months in the last 12 months. So it can't be more than 3 months all up in the last 12 months, unless the entire period of your leave you were on paid personal or carer's leave. Now let's look in the little box at an example of how this kind of claim could work. So Scott is dismissed while taking 3 weeks off work to recover from injuries that Scott sustained during a family domestic violence incident. Scott provided a medical certificate to the employer immediately after the incident, and there is no other apparent reason for the dismissal. So in this case, it may well be that Scott has the option of choosing between unfair dismissal or a GPD claim, but it would depend on whether Scott is in fact eligible for unfair dismissal. There will be plenty of times when you have a client or someone that you're supporting who's in a similar situation to Scott, where they're not in fact eligible for unfair dismissal because, for example, they haven't been with their employer enough time, they haven't met that minimum employment period. But if you can show that the reason that they've been dismissed was because they took time off and it was a temporary absence, then a GPD, General Protections Dispute claim, is certainly something you should consider. Thanks, Amanda. Now, I've been emphasising, I hope, that if the claim, whether it's unfair dismissal or general protections, if it involves a dismissal, you've got to act quickly because you only have 21 days to get that complaint into the Fair Work Commission, and the 21 days includes weekends. So it's 3 weeks from the date of the dismissal, and it is a very strict time frame. The Fair Work Commission can only extend that time frame if it is satisfied that there are exceptional circumstances justifying that extension. And in recent years, the Fair Work Commission has in fact shown a preparedness to consider family and domestic violence as an exceptional circumstance. So that's good news. Let's have a look at the next slide. So I'm going to give you a couple of decisions where the Fair Work Commission has considered whether or not to extend the time frame. So this first one that we're looking at from 2019, here the employee was employed on a series of fixed term contracts, and the employee basically put in the general protections dispute application 787 days out of time. And she argued that that the bullying and harassment that were happening in the workplace led to various mental health crises following her dismissal, and which required urgent care. And she also raised a marriage breakdown and experience of family and domestic violence leave, but did not in fact rely on the family and domestic violence. And in this case, the Fair Work Commission accepted that she had experienced a difficult time, but ultimately said there was a lack of evidence supporting her claims. And they also did consider that the substantive claim that she had looked like it was going to be weak based on the evidence. And so in these circumstances, they declined to extend the time frame. So remember, of course, like with everything in law, the more evidence you have backing up your claims, the stronger your claim will be. But when the Fair Work Commission is considering whether or not to extend the time, they will always consider both what are your reasons, but also how strong or weak do we think the substantive claim is. And if they think that the substantive claim is looking like it's weak, then it's going to be very, very difficult for you to get that extension of time. Okay, the next slide. Here we've got a decision from 2020, and here the employee was employed as a warehouse assistant for 5 years before being dismissed. His unfair dismissal application was 13 days late, and there was evidence that he had attempted to make a UD claim only 2 days late, so still late, but earlier than the second one that was finally accepted. And he did say that he gave evidence to the Fair Work Commission that that he had been experiencing family and domestic violence leave, and that had escalated during the COVID lockdown, and he gave a heap of evidence about that. And so here the Fair Work Commission noted that the applicant was suffering from severe depression and anxiety, nightmares and regular panic attacks linked to a history of repeated family and domestic violence. So that's really important because the evidence was there. And this was one of several factors that weighed in favour of the extension of time. So there you've got examples of both one unsuccessful and one successful extension of time application. Thanks, Amanda. So a quick practical example of how, again, JobWatch could help you. So let's go back, remember that case study that we considered before with Jean. So let's assume for a second that Jean now comes back to you And she explains that 5 weeks ago, she was dismissed from her job where she had been working for 3 years on a part-time basis. And she tells you that she was fired shortly after she told her boss that her absences from work were due to family violence, and that she was going to need to access the family domestic violence unpaid leave to organise some alternative accommodation. Jean tells you, because of course, remember this, she tells you that 5 weeks ago she was dismissed, so she's obviously out of time in terms of the 21-day time frame. But she tells you that after she was dismissed, she needed to apply for government assistance, attend job interviews and attend a hearing for her IVO, for the intervention order. She became overwhelmed and anxious, and her doctor provided her with heavy medication, which made it difficult for her to think clearly. So really what I want everyone to take away from this slide is that please don't ever say to someone, forget it, you're too late, you've missed the 21 days, and so there's nothing more you can do about it. Because of course we need to look at whether there is evidence that will justify an extension of time. If the argument can be made that Jean had exceptional circumstances and that her substantive claim is strong, then she should still go ahead with a claim, whether it's an unfair dismissal or a GPD involving a dismissal. Thanks, Amanda. All right, I know time's ticking. This slide is really, I want to raise with you all the issue of discrimination. So now I'm moving away from the Fair Work Act and I'm focusing on the fact that across Australia, in every jurisdiction, so state and territories and our federal laws, we have anti-discrimination legislation that protects employees and contractors from discrimination, as long as you can show that the discrimination was on the basis of a protected attribute. So, for example, gender, age, race, disability, etc. They are protected attributes. And in order to succeed with a claim of discrimination, you have to show that either you've been treated badly, so less favourably than others because of that protected attribute, or that your employer is seeking to impose or has imposed a condition or a practice that is unreasonable and that has the effect of disadvantaging people like you that have that particular attribute. Now, the important point here is that unfortunately, and despite lobbying by many organisations, including the Australian Human Rights Commission many years ago, started saying that we really need to have a separate protected attribute of family and domestic violence leave, but still, as at 2021, right now, unfortunately, we do not have that as a separate protected attribute in the anti-discrimination laws. So you can't at the moment go to the Australian Human Rights Commission or to any of our state or territory anti-discrimination bodies and say, I have been discriminated against in employment on the basis of family and domestic violence leave. The best you can do with the laws as they are at the moment is you can try to link the family and domestic violence leave to another protected attribute such as gender, but it has been done in Queensland. Amanda, let's have a look at the next slide. And in this particular case, unfortunately, that argument was not successful. So really, if you have a very good case, it doesn't mean that in future every single attempt to argue that discrimination involving a set of circumstances where there was family and domestic violence, and if a woman tries to argue that she was discriminated against on the basis of sex, it doesn't mean that the claims will always fail. There's always a possibility that that new precedent will be created, and that would be a great thing. But at the moment, we do have this decision of the Queensland Industrial Relations Commission that really means that it's going to be very difficult for women to make this kind of argument in future. I'm going to go on to the next, thanks Amanda, because of time. So very quickly again, in terms of OC health and safety laws, we all know that across Australia in all the jurisdictions, employers have obligations to keep us all healthy and safe. And where injuries from family and domestic violence arise out of or in connection with the employment, a woman or any employee who is suffering from family and domestic violence may be able to go ahead and make a workers' compensation claim. Usually when people call the JobWatch telephone information service about workers' comp claims, we will refer them to our Victorian WorkSafe authority or to the relevant WorkSafe authority in their state. And of course, those WorkSafe authorities will investigate claims and actually have the power to prosecute employers. Let's quickly go to the next slide. So I just want everyone to note that there was a recent decision of the New South Wales Supreme Court of Appeal in which it was indicated that in some circumstances an employer could actually be held responsible for the family and domestic violence that is perpetrated against an employee who's working from home. Let's go to the next slide, Amanda, and everyone, you can see the decision is the nominal insurer, the workers' comp nominal insurer and Hill. It's a 2020 decision. You'll get all these slides, so I'm not going to read out all the contents of this. But everyone, we are at the end of our time, and I want to give you an opportunity to ask any questions. Amanda, have we had some questions come through?
Yes, we do have two questions here. So the first one, Gab, is related to the NES and whether we can give some more information about where they can find things around flexible working arrangements in the NES. Yes,
of course. Thanks for the question. So the best place really would be the Fair Work Ombudsman's website, and that's fairwork.gov.au. If you type that in, and then you can just search for flexible work arrangements, and you will get all the general information there on that fairwork.gov.au website.
Lovely. And the second question is, what if an investigation takes place? They then issue a first and final warning, and then the next day say that your contract will not be extended and you will need to finish up in 2 weeks.
So is the, well, I mean, obviously it would depend. Is the, I haven't understood where the family and domestic violence actually fits into this particular example. Is the investigation into conduct, does it say, or?
It doesn't specify. So what I might say is, if you are the person who sent in this question, please feel free to contact our telephone information service. I'll just quickly pop that number up on screen now, and then we'll be able to give you more tailored legal information about that. Gab, I see we've got a third question that's come through. Will these slides be available after the training? Yes, we will be sending out an email to everyone who has registered with a recording and a PDF of these slides as well. And a question around, Gab, do we provide a template for developing family violence leave policies for employers? And if not, where can we find such templates?
Okay, so thanks for that question too. Look, JobWatch is specifically an organisation for employees and workers, and therefore, no, we do not generally provide assistance to employers, but there is the Fair Work Ombudsman that provides assistance to both employees and employers. And on the Fair Work Ombudsman's website, they do have a number of tools that do help employers. So I encourage employers to have a look at the resources on the Fair Work Ombudsman's website.
Wonderful. Thanks, Gab. I think that's all the questions that we've got today. If you have any other questions that come up once you've had a bit of a chance to digest all the information, please feel free to get in touch with JobWatch. Our contact details are up on screen at the moment. I might also note, you'll see up there on the screen, we've got a little icon around info sheets. So you'll find information sheets relevant to a lot of the topics that Gab's covered today in terms of, unfair dismissal, putting in GPD claims and so on. All that is available in info sheets on our website. So jump up there. And also, a reminder, we will be sending out a survey to all webinar participants in the next 24 hours as well. It will be really helpful for us if you're able to complete that survey, because your feedback can help us improve all our presentations into the future. And, being the comms manager, I also have to say, please follow us on social media. We're on Facebook, Twitter, LinkedIn. And if you enjoyed today's webinar and found it useful, please leave us a review on Facebook and Google as well. That's all from me. Gab, did you want to add anything?
No, that's it. Thank you so much for making the time to attend, everyone, and all the best. Please do contact either our telephone information service or refer people to that telephone information service, or if you are a lawyer or a caseworker supporting people in these kinds of situations, please get in touch with us directly at the JobWatch admin number, which is 9662 9458 if you are here in Victoria. So it's a Victorian number, 9662 9458, and ask to speak to one of the lawyers if you want to make a warm referral about a matter that you are dealing with and you believe it has merit and you need one of the lawyers to give some urgent legal advice. Obviously, that is, please keep this in mind, that is for people who are not union members and cannot otherwise afford private representation. Community legal centres are here to help people who would otherwise fall through the cracks. So if you've got those other support mechanisms, if you can afford private representation or you are a union member, please use those first before coming to JobWatch. Thank you so much.
Lovely. Thank you everyone for joining us today. And we look forward to seeing you at our next webinar, whenever we schedule that. Have a lovely afternoon. Thank you.
Bye.